This is the current federal tax developments for the week of February the 3rd, 2025. Current federal tax developments are brought to you by your state society of CPAs and by Kaplan Financial Education. This week, we're going to take a look at a couple of things. First, we're going to start looking at a tax court decision that found the property donated to a charity had a value that was less than 1/3 of what the taxpayers claimed on the return. As you may guess, that didn't turn out well when we got to the penalty phase of the case. So we'll talk a little bit about why the valuation was considered way above what was allowable, and also how everything kind of worked out. We'll also take a look at the IRS private letter ruling that found that most in vitro fertilization costs and surrogacy costs will not be deductible for a couple that was facing an issue, and we'll talk about why, what the problem is. And the IRS has returned to something that courts have done multiple times, which is the discussion of the fact that any expenses must be for treatment or function of the body, quote unquote, of a taxpayer, one of the two taxpayers, or their dependent. And this obviously complicates, especially when surrogacy is involved, that medical expenses generally being incurred by a party that is none of those is where the issue runs into. We're going to discuss that as we talk about this ruling. We're also going to talk about a taxpayer who attempted to get innocent spouse relief and why her request failed. There were a number of issues regarding her request, so we'll talk about what went wrong and why she had the problem. We'll also find an interesting reported tax court decision, but it was on a unique question. There was a challenge as to whether, in essence, the way the IRS Independent Office of Appeals is structured and staffed is constitutional. And we will tell you, hey, good news, at least you're the IRS. The court found it was constitutionally structured, but we'll talk about why it was even an issue, and apparently, it hadn't ever been directly addressed in this form. So we're kind of there. And finally, we'll talk about a case where the taxpayer got upset after the IRS fouled up on a couple of occasions in handling their case and refused to file proof of filing of the returns, and why that destroyed their ability to get any relief in a collection due process hearings, even though the IRS made errors. So this is probably a very good example case about why you've got to calm the client down. Even though the IRS fouled up, there's only so far that's going to carry you in terms of if you just want to play, quote, hardball. When you're playing hardball, you have to understand the consequences of playing hardball, because normally when you're playing hardball, there is a chance that the ball could come right back at you full speed, which unfortunately in this case it did. So let's start and talk about the first case, the Leo case, Tax Court Memorandum Decision 2025-9. That came down on January the 29th. And we'll talk about this case involving property donated to a charity. The question became the valuation of a piece of property donated to a charity and the resulting tax implications. In this case, we're talking about the fair market value of what was known as the bankhead property. It consisted of buildings that were used in manufacturing furniture and 136.4 acres of land in that regard. Now, in 1948, the furniture factory was built on the land, and from 1955 to 1972, the building expanded until it had over 1 million square feet. The factory operations, but not the building or the land, was sold in the early 2000s to K-Home. So we essentially had a factory operating from 48 through early 2000s, and now the factory is being transferred to another party. K-Home did not get the building. In 2002, Vanguard Property, in which Carl Lowe, who is a taxpayer in this case, held minority interest, purchased the bankhead property for $2.8 million. A portion of that property, the factory, was leased to K-Home. So K-Home, obviously they had bought the factory. They had, they have the operational part of the business, but they didn't own the factory. So the factory was leased back to, essentially K-Home. But yeah, now in 2007, Carl Leo became the sole member of Vanguard Properties, and the lease with K Home for the entire Bankhead property. K Home was not successful. In 2010, it went bankrupt, and its business assets were acquired by another company, Newport Furniture Company. But Newport lasted even a shorter period of time than did K. In 2013, they stopped paying their rent and declared bankruptcy. So now we have this longtime furniture factory. It had been operated from the late 40s all the way through the early 2000s by apparently, we don't know, it was just one company, but in any event, it seems to have been operated fine for that period. But then when it transitioned in the early 2000s, we had the first company that came in to run it. It operated for a while, but fell apart less than 10 years after buying it. And following that, the next company that took over the assets essentially lasted about 3 years, and then it failed. And at that point, we're pretty much done with the furniture building business. We're not going to be using it for that, right? And by this point, there were a number of issues anyway. The property itself, as you might guess, being kind of run, the factory being run for now 13 years nearly by companies that were financially struggling, at least toward the end of that period. The property was in disrepair. There were roof leaks, outdated electrical, and non-functioning heating and cooling systems. So building was in bad shape, shall we say, right? The director of industrial development of the local authority testified that that property was unsuitable for leasing due to its size, low ceiling, and poor condition. Nobody would want that building. And in essence, that thing was more of a problem than a benefit. At the end of the day, it was one of the problems we've got. It's kind of in there. We got this huge building, and it's way out of repair. Now, the taxpayer, faced with this, can't lease the building, decided to donate it to a charity, or at least partially. It was a combination sale donation. In July 2013, the Mercy Foundation expressed interest in purchasing that property. Right? On December 31st of 2013, Vanguard Properties, remember, is wholly owned by Mr. Leo, sold the properties to Mercy Foundation for $10,000 in cash and a $565,000 promissory note. Okay. The sale agreement included an appraisal by an individual named Campbell that valued the property at just under $16 million. So that would be one neat bargain sale. And obviously, if you have a bargain sale to a charity, you're going to get a charitable contribution for that discount, which is, of course, what they were going to claim on, or attempt to claim on, their return. Now, subsequently, a few things happened. Important to keep these in mind. In 2014, which means the next year, they canceled the promissory note based for $40,000. They essentially were able to buy it back. Okay, so that's interesting. We got it back down, so it's $40,000. And they went to sell the property. They sold the property in 2015 to a New Albany Acquisitions, which purchased the building for $1,130,000 and demolished parts of the building because of their poor condition. In essence, the place needed work. So now we have a sale, essentially less than 2 years, or about 2 years, we don't know how far, let's say 2 years after the initial interest was expressed, and less than 2 years after donation, for $1,130,000 on a building that supposedly, at the date of donation, was worth nearly $16 million. But remember, our only evidence it was worth $16 million was the existence of, that appraisal. So obviously, we're now going to be looking at the appraisal, because that's going to become the key issue. What in the world was that, and how to go it? Now, on his tax return, the Leos claimed a contribution of $15,225,000 on their 2013 individual tax return, based on the $15,800,000 appraisal, then reduced by the amount that the charity had paid and by the note they signed. Remember, the note that they essentially got rid of the next year for $40,000, but That was their value at that point. Now that wiped out their income entirely for 2013. And eventually they carried over this deduction to the years 2016 and 17. Those are the years that are before the court in this case, because that's the issue. So it's important to note that we are looking at, that particular background, what was going on. Now, they later made adjustments to the carryover deduction based on the cancellation of the promissory note. So I'm guessing, basically saying, yeah, since that was canceled, we actually had a bigger contribution. So all of those issues go in. Now, at trial, the taxpayers argued that the photographic and descriptive contents of the Campbell appraisal valuing the property at just under $16 million were binding in this case, right? It was at the time, it was there, it was years ago, it's binding, we have that in place, it's good. Yeah, not so quickly, though. And we'll talk about that later. Now, the Leos probably recognize that they might have a little problem here. And in fact, there are a couple of problems that are going to come up, we're going to discover, including the fact, as we'll mention later, that Campbell had told them that essentially he had kind of guaranteed them a $15 million value. He'd committed to that. So, okay, that's a question. So they brought in Mr. Singleton, who valued the property at $12,425,000 using a combination of comparable sales and income approaches. But they thought that might even not hold. So at the end, they said in their closing statement, they present a fallback valuation of just under $8 million based on separate values for the land, the office space, interior finishes, and the building, depreciated from their insured value based on their insurance policies on the properties. So probably tells you right away we think we have some issues when we got three different values offered up to the court already in terms of defending our position. So I'm not going to say they ceded the Campbell position right away, but they certainly didn't appear to have enough confidence in it to say this is what we're saying. So we end up with that. And in reality, it appears they tried to lean more heavily on the Singleton appraisal coming in later. Probably I suspect, that $15 million pledge from Campbell. Trying to say, well, okay, $15 million, yep, he pledged that, so maybe he brought it in high, but we brought this other guy in, he looked at the evidence the guy had, etc. So he's saying it's $12,425,000. So that would still give us a nice, really big deduction. And even if you don't buy that, well, we think it's worth at least $7 million, or at least $8 million. So, we're going to take a look at that realm, just based on the insurance company was okay in insuring it at $8 million. Okay, what did the court come up with? Well, the court cited Treasury Regulation 1.170-1C2, which says fair market value, as we're kind of used to, is the price at which the property would change hands between a willing buyer and willing seller, neither under any compulsion to buy or sell, and both having reasonable knowledge of all relevant facts. The court determined that while the Campbell appraisal was admitted into evidence, they accepted it as evidence, they found it essentially wholly unpersuasive. Okay, which, as I said, given the fact that we have at least two other positions to back it up, the taxpayers did, I don't think that came as a total shock to the taxpayers or their counsel. That one might not hold up, right? The court found that Campbell's view of the property's condition was not credible and suggested his objectivity was compromised by a pre-existing commitment to value it at least $15 million. Yeah, that's a bad fact. I know we all know kind of how valuation works, and that, parties are kind of aware of the value they want. But yeah, getting it in writing, probably, or in some other binding commitment, is probably not the best approach before the property is valued. It rendered whatever you paid for the Campbell appraisal pretty close to worthless the minute you got that in play, right? The court said there was no evidence he reviewed the photographs that were taken by Mercy's Foundation's environmental consultant, who had photographs that showed something in pretty bad condition. I mean, they had lots of photographs about that documented the condition of the building. And apparently, Mr. Campbell had never actually looked at any of that stuff, right? It rejected, he had presumed the electrical and plumbing systems were in good condition. Yeah. They said that's one heck of an assumption to make on buildings that were in this bad a shape. So we're not going to assume that that was fine, right? The court also found the second Singleton opinion, expert opinion, unpersuasive. The first problem was that he relied too much on Campbell's conclusions. Again, seemingly this, you kind of attempt to kind of patch up the original one, make it go because that's got the big value, right? So he got a little bit too heavily on conditions about the bank's head property and did not, in fact, conduct his own thorough independent inspection of the property to come to a conclusion about its condition. So that's a problem. He said his reliance on comparable properties was flawed because those properties were in way better condition than this one. It's like comparing a car that has just been totaled in an accident, right? In a heavy accident, so it's not really going anywhere, against a brand new off the showroom vehicle. Yes, they may both be the same model of car, but yeah, it's pretty clear which one is worth more than the other. And the value of the showroom car is not really terribly important if you're just trying to buy, as opposed to get an insurance claim for, the car that just got totaled. And that was kind of where we ended up with the bankhead property. Right? The court disagreed with Singleton's income approach, noting that his $1.50 per square foot estimate of the rent was high, especially given that there had only been a 48-cent per square foot arm's length lease the last time it had been leased with Newport Furniture. Why had it gone up 3 times on a building that, if anything, was in bad shape and went to worse over time, right? The 45-cent per square foot rate in the Newport home lease, right, in that case. And the court noted that his assumption of a 20% vacancy rate was incorrect, given the reality that only half the building area was under lease. So yeah, you can't assume that we could lease 80% of it, because no, only half it had been under lease at the end part anyway. So it's like all of it's wrong. His income numbers are way too high, right? And he said finally that valuation was simply totally inconsistent with a $1,130,000 value price in 2015 when it sold on the open market. And that's, it's like, why in the world was it, what in the world happened from, the day it went out until the day of the sale that would have caused it to have declined that heavily? Right? Saying that just doesn't make sense, that it had been worth that much more. I remember that was going from 2010 to 2013. So, or I should say 2010 to 2013, which was, get myself back in there, when it came through, when it finally got sold, or 2013 to 15. I get my dates right. The date it was contributed, the end of 13, to the date it was sold sometime in 15. How in the world had it dropped that drastically in that period? That just didn't seem to make sense. They did find the IRS's expert witness to be persuasive, the court did. This is the Ladner valuation. Ladner determined a value of $4,050,000 using comparable sales approach, adjusting for the poor condition of the property and deferred maintenance. Now, you might say, given what it finally sold for, that $4,050,000 might be generous. But okay, and I think the court's thinking that too. It's like, well, that's if anything on a generous side. It gave no weight to the land valuation approach proposed by Ladner, as a typical purchaser would focus on the building area for a property of this type. Right? They're not really looking at using the land for other purposes as to what they're going to do. Now, they found the conclusion was supported by the fact that this person actually inspected the property, right? Yet interviews of former tenants to find out the condition of things. He took a look at the poor condition photographs from the environmental consultant. The other person had been on property, and had, documented the shape of this building. Right. The fact only half the area was leased at below market rates, and the later demolition of a portion of the property, all led to the conclusion that, this one, the lowest of the 3 proposals, was probably the closest to correct, right? And it rejected the argument that he should have used an income approach. Simple problem was the property wasn't in a position, as was testified by the local development group, local development officer, wasn't in a position to be rented, right? It was in a horrid condition. When it finally was purchased, they essentially tore down a chunk of the stuff and heavily redid things. So yeah, it was in no condition to be leased. It had no income value. Okay. Why'd they reject? But what about that fallback insurance company position? Why didn't they at least go for that? If the insurance company, based on their value plus depreciation, why didn't the court accept that fallback position? Well, clearly they dismissed the value, and they rejected their claim that $40 per square foot should be used to value office space, which was contradicted by the fact the space had to be gutted in later renovations. So I don't care what the insurance policy said, that was worthless space generally. Determined that it was improper to rely on the insured value of the property, determined the value of the bulkhead property. The insured value was not really based on, what you could sell it for. So they're saying, no, we're not going to do that. That wasn't the reason why the insurance company, chose their values. That wasn't based on, any of those things. And yeah, this was not meant to be a value to be used in exchange. So yeah, we're not going to use it for that purpose, right? So they held the fair market value of the property was $4,050,000 as determined by the sales comparison approach, including that the property was in an inferior condition. There was no reason to use an income approach because this thing couldn't generate income without a ton of work being done on the property. And by the way, when you buy property that needs a ton of work, the value of that property is going to be substantially lower than the value of property of when you could buy it with a building that didn't need any of that work, right? Especially a building of that size. They reasoned it was supported by the facts that only half the property was leased at the valuation date. The unleased portions could not be rented out. They were totally, unable to be used at that point, and only sold for $1,130,000 in May of 2015. Ultimately, as they cite the estate of Kaplan versus Commissioner, which was a Sixth Circuit decision from 1984, that stated in that case, little evidence could be more probative than the direct sale of the property in question. The property sold for, $1,000,001. That suggests strongly that it was not worth nearly $16 million about 2 years earlier. It seems wildly unlikely unless the property had been, some major event had taken place to drastically reduce the value of the property in the time period. And the court found nothing had been suggested that, if anything, the value would probably go up to some extent because it hadn't gotten worse. And the new buyer came in and started, did their own upgrades. And of course, the charity, was under no compulsion to sell it off at a bargain sale price. They really, if it really was worth way more, you would presumably the charity would have gone for way more because they've been a willing buyer willing to pay way more than $1,000,001. What about penalties? Well, now this is interesting. Remember, right? The actual year of the donation, they would owe no tax either way, even with the $4,050,000 reduced for the sales price donation the court allowed. They still would have owed no tax in 13, right? So in essence, that wasn't really the problem on the return where the value was claimed. It hadn't caused an understatement of tax. But they did note that in 16 and 17, the years we carried it forward to, right? It was impacted by the gross valuation misstatement, and that the tax benefits in those years that had already been claimed and paid, that would be subject to a 40% gross valuation misstatement. And it doesn't matter if the taxpayers acted reasonably. The court points out that this particular penalty is a simple mechanical one. And unlike a lot of penalties, including, just the general purpose, negligence or substantial understatement penalty, there is no reasonable cause exception. the penalty for gross valuation misstatements, which means that even if they had reasonably relied upon their tax advice, had reasonably relied upon the appraiser, they didn't have any reason to believe the valuation was out of line or the deduction was inappropriate, they'd still be hit with this penalty, right? It does not allow for reasonable cause exception, right? So that would be they'd be hit with that valuation penalty because they claim benefits in 16 and 17 years. And because they'd claimed in those years relying upon an overstated valuation, that was when the actual tax benefit took place. That excess valuation on which they had relied upon and claimed a tax benefit meant they were going to have to pay, in addition to paying back the tax and the penalty and the interest, they have to pay a 40% penalty on that excess based upon the fact that, they had overstated their claim deductions. Next up, we're going to go to a private letter ruling, 2025-05002, issued on January 31st. And this is a ruling looking at expenses related to a taxpayer's in vitro fertilization surrogacy and whether or not they could claim a medical deduction under Section 213. Now, I will say, a lot of cases, this question is an indirect question for whether or not it could be reimbursed tax-free under a, FSA account from the employer who may be looking for this ruling because, again, the amount has to be allowable under 213 for it to be okay for FSA accounts, or even potentially a taxpayer looking to take an HSA, distribution to cover it. So it may really be a Schedule A, we don't know, or it could be kind of hiding for one of those two. But in either case, it would make the same difference. And addresses the deductibility of medical expenses related to in vitro fertilization and gestational surgery. I love that. Surrogacy, basically. Surrogacy. Now, the facts of this case. Now, this first fact seems like, okay, the taxpayers are a legally married heterosexual couple. I suspect that they were hoping that there had been prior rulings where there had been a same-sex couple, both of whom were male. Okay. So that meant that it wasn't that one of the couple, had a medical condition that rendered the party unable to give birth, right? No, it was not. They basically were, it was just a standard old genetic, deal that not there. Can't give birth. So I have a feeling that's why this statement's here, because otherwise it does seem a little bit odd as to why we're saying this, but they are. So they're a married heterosexual couple. And in this case, taxpayer A, the woman, was diagnosed with medical conditions, multiple, that required medication that simply was contraindicated being used. You couldn't use it in pregnancy. So, okay. So she would be unable to carry a baby. Okay. We know that right away. Okay. Due to her condition, the couple will use in vitro fertilization with the man's sperm and a donated egg and a separate gestational surrogate. So we have basically the husband who's going to be the sperm donor. We have a donated egg from another woman, not apparently taxpayer A. Presumably, she also was not in a condition to do that. And, and they will have a gestational surrogate to carry the pregnancy. So, and obviously that last one is absolutely necessary, right? We need basically somebody to carry the child to term. Because again, taxpayer A, is unable to be the person to do that, right? Due to her medical condition. Now, they wanted a ruling on deductibility of various costs, and some of those they were asking about included medical expenses directly attributable to the spouses themselves, egg donor costs, medical expenses of a sperm donation, sperm freezing, in vitro fertilization medical costs, embryo creation and egg storage, childbirth expenses related to the surrogate, surrogate's medical insurance during the term, legal and agency fees for the surrogacy, and other medical expenses arising from the surrogacy. So basically, all the fees they're going to incur in order to essentially, have the child they're asking about which one of these are deductible as medical expenses under Section 213 of the Code. Now, the law. IRC Section 213A allows a deduction for medical expenses for the taxpayer, their spouse, or dependents. Okay? To the extent these expenses exceed 7.5% of adjusted gross income. They must be compensated by insurance or otherwise, and the payments do include insurance, right? Now, it defines a dependent as a qualifying child, including a child of the taxpayer. This is important because the sperm and even basically the sperm, the egg, and even the embryos are not really a dependent under federal law, right? There's no dependent until there is a live birth, right? We need the birth of the child. So indirectly, we're going to discover one of our problems is, because I'm sure somebody's trying to backdoor this through the embryo, right? Let's go that route. And saying, nope, that doesn't really totally cover it. And the other big definition here, 213D1A, medical care is amounts paid for the diagnosis, cure, mitigation, treatment, and prevention of disease, or for the purpose of affecting the structure, function of the body. This also includes medical insurance. Now remember, medical care expenses have to be incurred for the taxpayer, their spouse, or dependent. And you're going to find that linking up 213A and 213D1 Cap A is what's going to cause the problems here. There are definitely medical expenses being listed here for a lot of these things. However, way too many of them are not being for the care of the taxpayer, the spouse, or dependents of the taxpayer and spouse. That's the problem. The surrogate and the egg donor are both their medical payments to them, potentially, or for things that may be medical care, but they don't directly relate to the taxpayers in this ruling. And, the IRS cites several cases that have made that link over the years. Right. The issue is they've denied deductions for reproductive technology expenses such as IVF and surrogacy when the taxpayer, spouse, or dependent did not personally use technology or have a medical condition requiring them. The cases that, if you want to go look at them, include the case of Morrissey versus United States from the 11th Circuit, Lagino versus Commissioner from the tax court memo from 2013. It was affirmed by the 11th Circuit in 2014, and Magdalene versus Commissioner, which is a 2008 tax court memo decision, which was affirmed by the First Circuit. You have those cases involved with this. Okay. Now, okay. So, like I said, the bottom line of that case is very simple. The medical expenses. Now, what they did allow was medical expenses for the husbands. Anything that was for the husband. So the sperm donation expenses, generally those are fine. Those were deemed to be items affecting him. And because he was one of the taxpayers, right? Married couple filing joint return, expenses directly related to him are fine, but pretty much everything else is off the table. And therefore, no, it did not make a difference. The IRS never really commented on it. The fact they were a married couple and they were a heterosexual couple. And one of them, prior to the medical condition, did have the ability to, in essence, right, to have a child, would have had the ability to have the child. So, yeah, it doesn't matter that there was a female. Is fundamentally kind of what the question was. Did that matter? No, not really. There was a male, there was a female. Yeah, we understand how that works with getting a child, but that wasn't enough to say if there's a problem with one of them, can we open up the door to paying third parties' medical expenses? Answer of the IRS was no. Next up, we're going to have a bench opinion. We're going to have a couple of these this week because not much is happening with change administrations, etc. We're getting mainly court opinions now to work from. So we're going to be looking at these, and we had to go to a couple of bench opinions this week. This was a case of Carol Gomez versus Commissioner, docket number 3339-25S, which is a tax court bench opinion issued on January 29th. Now, this is an oral opinion rendered by the court and transcribed later, in essence, by the transcribed later and then published later. So while it was published on the 29th, it actually was completed, I think, about a little less than 2 weeks earlier was when the actual, oral opinion was rendered. Now, this taxpayer was looking for innocent spouse relief from joint and several liability. She was saying, hey, she had this joint and several liability on her debt. Now, she actually prepared the return using tax software, and both she and her husband reviewed it before filing. So she prepared the return, they both reviewed it and signed the return. That much was a given. Right? The return reported IRA distributions of $6,000 with a taxable amount of $0 and pensions and annuities of $103,174 with a taxable amount of $555. Now, we'll get to a later point where the court made a statement that's a little weird, that she didn't realize, a portion wasn't taxable. I think that's an awkward wording, probably because it was oral. I think what the court meant, and I did review the transcript, it's like, it does say that. I went and double checked. Does it say? Yeah, it says that exactly. It's like, okay, it's awkwardly worded. Presumably, I think what was meant was that she didn't know, she had no reason, she couldn't explain why part of it would be non-taxable. However, the return showed it as the IRA non-taxable entirely and the pensions and annuities taxable for only $565. My guess is we're looking at tax software just being relied upon and the old line from computer software of garbage in, garbage out. In essence, there were entry errors made here. They may not have totally understood how to use the software, which is the most likely answer, because most software I'm aware of, even consumer software, will get this number right. It's not that difficult, but only if it's got the right inputs. My guess is she got confused, or they got confused because he obviously didn't spot the problem either, and just thought somehow it was there, and probably did the old line thing of, well, the computer says this, it must be right. Hint, it doesn't have to be right. Okay, that would be the big problem that's going to lead to the issues here. The refund reflected a total tax of $2,801, the withholding of $30,608, which is sad, because it means that they had enough withheld, almost certainly, to have paid for, the tax on that $103,000 from the pensions and annuities that he took out. By the way, these distributions came from his accounts, and as we'll discover, he has a bit of a gambling problem. Yeah, so we'll get to there eventually as to how that goes, right? Now, in July 17, the IRS audited the return, not surprisingly, because that's way out of line with what with what total distributions were. And they determined they owed additional $24,000 in tax due to the retirement distributions, as well as an accuracy-related penalty. The IRS did waive that penalty, so we're not going to talk about that. Penalty is not in play. The IRS did waive it. They said, yes, they tried, and I would assume they could get this would be eligible for reasonable cause, and I'm guessing that, they tried and they didn't intentionally screw this up, but, it still was wrong, regardless of how you looked at it, right? Now, they entered into an installment agreement in December of 2017, began making payments from February 2018 through May 2019. Several income tax refunds from their joint returns for 17, 19, and 20 were applied to their outstanding 2014 liability, with the first offset coming in April of 2018. This will become important when we get to our innocent spouse claim, right? That first offset. Because, by the way, offset is a collection action. Okay. Now, she had not been living with him since 2012. We don't know why and how and, what was, but we have some ideas. He apparently, as we noted, has a major league gambling problem. Okay. He filed for bankruptcy protection in May of 2019. This is bad if you're jointly and severally liable for the underpayment and the installment agreement, because now it's a problem if he gets out from under it. And secondly, even if he doesn't get it dismissed, the problem is going to be that he's probably much less collectible than she is, right? On November 15th, she filed requesting innocent spouse relief for 22, right? From joint and several liability for the 2014 tax year, which IRS treated as a request under relief of 2015 B, C, and F. Okay, 6015 is where we find innocent spouse relief provisions, and there are various options. These are the three that might have applied to her, right? So they looked at that. She did answer no to the question whether she was about fear, danger, or abuse from her husband. Is she concerned? Is he threatening her? Do other things? She said no. Okay, so we have to take that as issues. We discover she will claim she was afraid of something different, but we'll get to that later in the court, what they're from. She also is a 22-year veteran, but they also, they took a look to see, is she suffering from post-traumatic stress disease due to her service? Was she ever been diagnosed with that? Because that also could help explain why she might be disabled and have been unable to raise defenses timely. She might have, there are various ways we could have extended the statute. So they said, well, do we have that? The answer was no. Any other thing, but that was thought being 22 years in the service, and we would presume, looking for PTSD, that she served in combat locations, that that might be there. So no, that's never been an issue with her. So okay, where do we stand now? We're looking for innocent spouse relief under 6015B. This allows the spouse to relieve liability if certain conditions are met, such as not knowing about an erroneous item on the return, right? There's also C is the separation of liability. It permits the spouse to limit their liability to portion deficiency attributable to them if certain conditions are met. And then there is 6015F. This allows the IRS to grant relief if it's inequitable to hold a spouse liable, considering all the facts and circumstances. So these are three that could have been in play. And note I said could have been. That's going to be a big problem for Ms. Gomez. Okay. She argues she should not be held liable for additional tax. It was her husband's retirement distributions, right? He made the withdrawals. She did not receive a significant benefit from the funds because he gambled it away. Let's be blunt. That's kind of what she ends up saying is, he used it to pay off the loan sharks from his gambling debts, or to try to pay them down, right? And she was not aware the tax distributions were not fully taxable. Apparently, she accepted whatever came out of her tax software, so I'm going to assume is happening. Yeah, the wording of that, she's not aware the distributions were not fully taxable. It's awkward wording. In the opinion, I'm not, it's like, and it's word for word how the court phrased it. So it's like, yeah, we're going to have to work with that one a little bit on interpretation. But I suspect the case is she just, she just gave the software numbers and responded to questions. And she obviously responded to one in some way, shape, or form that caused it to exclude most of it from income, which, yeah, there's no obvious reason why it would be excludable. Right. Now, first, the claims under B and C. Remember, B and C looked at, there are some ways if she just wasn't aware of it, or if she, it was related to her other spouse, that she should be able to get out of it. But the problem is, claims under these sections must be made within 2 years of the IRS's first collection activity. Remember the offset in 2018? Yeah. The ship sailed on claiming relief under these provisions in July of 2020 because it was more than 2 years after the first collection activity the IRS undertook with regard to this account. They did an offset. So, unfair as it is, those two have hard and fast dates on them, right? Collection activity, including offset and overpayment, right? In this case, that occurred, in April of 2018. And by April of 2020, when she hadn't filed for the claim, that was troublesome. She lost her 2 years in that realm, the 2-year statute. Okay, so bad news, but remember a few years ago, we had a case that said under 6015F, we talked about equitable relief. right? We have a different option. So yeah, we can do that. The court applied the 7 non-exclusive factors outlined for equitable relief. Now, equitable relief, a couple of years ago, we had a ruling that can't be time limited, right? Saying Congress, equitable relief meant when the other things, for whatever reason, don't work, but it's simply inequitable to hold her liable for the debt. And the IRS and Revenue Procedure 2013-34 outlines 7 factors. Now, no one of the factors is determinative, quote unquote. In reality, the court is meant to weigh the various factors and, determine whether overall they weigh in favor or against granting relief to Ms. Gomez. So now they're going to look at, does she qualify under 6015F, the only provision available to her? Well, first, what is the status of the marriage? And they said, okay, this weighs in favor of relief because she'd been separated from her husband since 2012. Right? So she was not married to him. I should say not married. She was married to him, but she'd been separated since 2012. And, and remember, it was in 13 he took the money out of those funds. Now she's aware he took it because she prepared the return. It's kind of hard not to be aware. Where does 1099-R come from and why? Right there. She also indicated on the form that her income, exceeded her expenses, so she couldn't show economic hardship would be suffered. In this case, I'm sure she would disagree with that. But what they're saying is you essentially can pay your bills. So, you do have funds to pay that could be directed towards liability. So that weighs against granting relief, that economic hardship. Knowledge. Did she know about the issue? Yeah. This factor weighs against her as well because she knew her husband had withdrawn the retirement funds and she reported those amounts on a joint return she signed. Right? So that's important to remember. She signed a joint return in 14, fully aware, right? Fully aware that in 14, when she signed the return, and it was 14, he took the money out, that, he had withdrawn retirement funds. That was it. She didn't say, I'm not signing this return. You got to pay this. That was the time to bail. And obviously, she bailed then. It wouldn't have been a problem at all. So hindsight's great. And I realized it probably would have cost some more tax in total. And I realized she thought there was no tax due on that because of the tax software mess that took place. But, tough luck at this point. What about, was the husband under legal obligation to pay the outstanding liability? This is normally when we look at things like court decisions, like in a divorce decree, even though she's still technically liable because the IRS is not party to the decree, they would consider it in granting relief if, in fact, the court had said that he should pay this liability in a divorce decree. But this was neutral because there's no indication the couple had determined who had obligation to pay the outstanding liability, particularly since the husband's bankruptcy was still not completed. That's also not terribly surprising that we're still sitting there. He's not yet completed his bankruptcy case. My guess is, yeah, there may be lots of issues. So that's still dragging out. Did she gain a significant benefit from the refund? Now, this factor weighed in favor of her. She testified that her, husband had pawned her truck to pay her gambling debts, and essentially she did not receive a significant benefit from the withdrawn retirement funds. Yeah, he was paying gambling debts apparently to loan sharks, which is, not a good thing to be happening. Also not sure they respect bankruptcy judgments, but that's another issue. We can deal with that. So, yeah. The court didn't really say it went to fund the gambling debts, but I wouldn't doubt it. That was probably a big issue. She did comply. She'd filed with her returns, and there was no evidence of future liabilities being created. There was this one bad year that they owe a lot of tax on. There was $24,000 worth of tax on, but that was one bad year. So that weighs in favor of her. The mental or physical health, this was neutral. Again, PTSD, this is where I'm kind of looking there. She did not suffer from PTSD despite her, 22 years of service. She did not report abuse or other health problems on her 8857. Now, she did testify she was scared of loan sharks seeking to collect her husband's gambling debts. She said no, that she lived far enough from her husband that they thought this risk did not appear to be an issue. She basically lived far enough apart from them. She didn't have any sort of, she has a vague fear of them showing up, but didn't indicate that that was the reason why she signed the joint return, et cetera. There's, all of those things, that had some impact on why she filed the joint return with him and why she hadn't taken action previously. So bottom line, the court emphasized the factor of knowledge is a key one here. Was she aware? The problem here is she was aware he took money out of the retirement account when she signed the joint return. It wasn't oh, wait, the IRS examined this and he forgot to give you this stuff. Right? That's the sort of scenario that could work much better in her favor. It's not that by itself it's enough to kill it, but it's there. She was aware of those distributions. She reported them on the return, and there was no evidence that she was abused or feared any harm from her husband when reporting this information. That's what she did. He didn't tell her to report as non-taxable because he needed to use that refund to pay, the loan sharks off. We don't have any of those things that he threatened her or anything. Unfortunately, he definitely had issues. I think we can say that very safely. He definitely has issues, but not in this factor, not in this method. She didn't claim that he threatened, he imposed any sort of thing, that she had any, in essence, all of this. Now, might she have benefited from somebody, it appears, as I would believe, she was pro se in this. Would she have benefited of having talked with a professional ahead of this? Maybe. Maybe discussed and let her know what should have gone in that first notification. But I'm sure, she's looking at financial distress. She's looking at all those problems. It's very stressful, and she's, just kind of looking at getting this done. And she's handled her tax stuff on her own in the past. She felt she was capable of doing this. There was a little contraindication back from 2014 that maybe sometimes there's tax stuff she didn't know. But in any event, the tax court concluded that based on this record, she doesn't qualify for relief. The installment agreement stays in place. And, because I'm assuming he's financially not in the greatest shape, she's probably going to be stuck having to, pay this thing off, at some point, trying to get rid of it. Again, lots of issues here, lots of problems. But it's a sad story. And there's probably a whole lot better chance that she would have gotten relief under B or C, especially C, because it was clearly his issue. But that's, she just waited too long to bring the matter up. And by the time she did, the 2-year clock had run and C was out the door. And because there was no legal obligation, she was in trouble. She just couldn't get this fixed right now. Next up, a reported tax court case, which usually says, oh, wow, that's got to be something really unusual. Some big deal that's going to be probably not as big as you'd think. Well, in theory, could have been if the taxpayer had been right. However, let's put it this way. The appeals office thought the taxpayer's argument was a frivolous one. And the court didn't exactly find it. I got to say the court didn't go as far as say it's frivolous, but the court didn't find it very compelling. We'll phrase it that way. This case raised constitutional questions regarding the structure and staffing of the IRS Independent Office of Appeals. Is it structured in an unconstitutional fashion? Interesting question. The petitioner, Charlton C. Cook III, sought a review of the notice of determination that sustained a federal tax lien or proposed levy action, which stemmed from his unpaid taxes related to years 2012 through 2017. The IRS issued a final notice of intent to levy and a notice of federal tax lien filing, which prompted Mr. Cook to file a CDP hearing request, right? Which he requested, and both a CDP lien hearing and a under 6320 and a 6330 levy hearing. Okay, so he requested both hearings. These requests were combined. A single hearing was conducted, right? During the hearing, he raised what he said were very much had to be addressed before anything else happened. constitutional arguments concerning the separation of powers, particularly the appointments clause, and why the appeals office structure violated the U.S. Constitution, and that needed to be solved before the matter could move forward. Now, the appeals officer who was assigned to it, Herring, explained that frivolous issues should not be considered, so he was going to skip by that. And ultimately, they rejected his proposed offer in compromise and failed to reach agreement on the installment agreement. So basically, total failure at the CDP hearing. Right. On January 5th of 2021, the team manager issued the notice of termination after approving, the appeals officer's findings, sustaining the federal tax lien and proposed levy action. Right. And the court notes the chief of appeals did not participate in this hearing. That's actually going to become an important detail here because of how we're going to go down this path. So, what in the world was the taxpayer talking about constitutionally? Okay. Now, he had two arguments here. He had an appointments clause motion arguing that appeals officers, appeals teams manager, and a chief of appeals are officers of the United States who must be appointed under the appointments clause of the Constitution and be confirmed by the Senate. Right? They're officers of the U.S. government. And of course, none of those are, right? And a separation of powers motions, arguing because essentially of how the chief of the Office of Appeals could be removed, that violated the separation of powers and ignored Congress's responsibility in this area. And so as such, there were fatal flaws in the structure of the IRS Independent Office of Appeals. Question, is Mr. Took right? And that's what the court sought to address. Okay. So, on the appointments clause motion, he contended that appeals officers who conduct CDP hearings are inferior officers of the United States who must be appointed according to the appointments clause as described in Article 2, Section 2, Clause 2 of the U.S. Constitution. And he argued that team managers who review and approve those terminations are principal officers who must be nominated by the president and confirmed by the Senate. Right? None of those things happened. Right? That's not how these things worked. Right? They weren't done under that structure. Right? He asserted chief of appeals, who is responsible for supervising and directing the appeals, is an officer of the United States and must be appointed per the appointment clause, and argued that all actions taken by those in these unconstitutional actors should be voided, and this case should be remanded to appeals for a constitutionally compliant hearing, which is going to take a while because we're going to have to get, in essence, a chief of appeals that has to be nominated by the president, has to be confirmed by the Senate, right? All those things have to happen. And then we have to do the proper things for all the others, and it would be a bit of a mess, right? The whole thing is totally fouled up as structured, right? Now, the separation of powers motion, which is removal, power is really the question, which says if they are officers, they can't be removed the way they are, right? He argued that the chief of appeals is subject to an unlawful removal restriction because the chief can only be removed for cause. He argued that this unlawful restriction impairs executive oversight and accountability, making the appeals office unconstitutional. That in essence, the president is not allowed to just, discharge the chief of appeals for no cause, which is a problem. And he urged the court to set aside all agency actions as beyond their rights, beyond their capability, ultra vires, right? I think I got the Latin pronunciation quick there, but beyond the scope of what the agency would be allowed to do under the law. Okay. Now, the tax court first looked at the question of, did he have standing to raise these issues? And it actually gave a split decision here. The court found that he had standing to challenge the appointment of appeals officers, appeals teams managers, because he had suffered an injury. The question is, in order to go to court, generally you got to have what's called standing. And generally it means there must have been something that happened to you, right? And that party that you're suing had to have been a party that caused an injury that allows you to go to court. He said, well, he had standing because the appeals officer and appeal team manager had made a ruling that if beyond their authority was a direct concrete injury from their actions. So he had standing to challenge their appointments. However, he determined he lacked standing to challenge the appointment of the removal of the Chief of Appeals. Chief Appeals had not participated in his hearing, did not injure Mr. Took because the Chief of Appeals had not injured Mr. Took. The Chief of Appeals, right, he can't challenge his appointment. Only somebody directly affected by the Chief of Appeals could challenge his appointment, right? And that wasn't Mr. Took. So it said, so we don't worry about the Chief of Appeals here, right? We're going to go and look back at the other appeals officers, right? And then classification of the appointments clause, officers of the United States versus non-officer employees, which are which, right? United States versus Germain from 1878. It indicated that officers have tenure, duration, emolument, and continuing duties. And Buckley versus Vallejo defines an officer as an appointee exercising significant authority. The court found officers of the United States must be appointed under the Appointments Clause, whereas non-officer employees or lesser functionaries need not be. So the question is, were the people that participated in his hearing, are they officers of the United States? Then we looked at principal officers versus inferior officers, right? Two types of officers are recognized by the Appointments Clause. Principal officers are nominated by the President, confirmed by the Senate, and inferior officers who can be appointed in a manner Congress deems proper. So the question is going to be, are they either of these, and does their structure violate either of these rules found in the Constitution? So let's apply these to appeals officers. Appeals officers do not exercise significant authority, right? In essence, is the ruling the court had. Appeals officers lack the authority to administer oaths, compel witness testimony, subpoena witnesses, or enforce discovery orders, unlike special trial judges of the tax court and administrative law judges of the SEC, who are classified as officers. They're saying this is a step below those levels, right? This is a lower level function. While they do have the power to settle cases and resolve disputes, this is insufficient in of itself to qualify them as inferior officers, right? Now, appeals team managers, what about that? Okay, so we know the actual appeals officer that heard the case is not an officer. What about the appeals team manager? Appeals team managers also do not wield significant authority, noting they lack the formal powers of administrative law judges under the Administrative Procedures Act. They don't have those levels of powers under the APA. So ultimately, the court found that Mr. Took's appointment clause motion as chief of appeals, denied that, finding he lacked standing to raise it, and did not reach the merits of that claim. So that's for another day to determine whether or not the appointments clause, impacts the chief of appeals office. They're saying that's something we're not even going to get into because it's irrelevant. This is not the proper venue, and he's not the proper plaintiff to bring this matter up. So not there. And then he said, as appeals officer, appeal team manager, they're not officers of the United States and do not need to be appointed according to the appointments clause, right? Basically, their structure. So, bottom line, denied in its entirety. As we said, it couldn't do either. Finally, the taxpayer that got upset the IRS in the middle of a proceeding as things happened, and the IRS definitely did foul up. But unfortunately, throwing, quote unquote, I love the British phrase, throwing your toys out of the pram. Doing that doesn't work in this case. This is Nelson v. Commissioner, tax court. Again, another, basically, trial opinion, an order dictated. So an oral order dictated. This was tax court case number 5223-19L. The order was finally appeared on January the 27th. Bottom line, a taxpayer is fair to provide additional requested financial information and proof of compliance with other tax filing obligations was found to justify the IRS Office of Relief Collection Due Process hearing despite significant IRS procedural errors. You want the too long didn't read summary, that's it. Not providing, refusing to give the IRS financial information and proof of compliance with your filing obligations is an automatic disallowance in a collection due process proceeding. Don't need anything else but that. It rendered everything else moot. And unfortunately, the taxpayer, as we're going to discover, decided not to provide that data because they got upset with the IRS screwing up the process, which they did. There's no question. Okay. As was noted in the order, the IRS botched the hearing. That is the literal language of the opinion. The IRS botched the hearing, however, by sending some important correspondence, including the notice scheduling the hearing, to the wrong address. Yeah, they had a lot of problems here. That also meant a last chance letter went to that same wrong address. So we then raised the stakes of screwing things up by another, right? And the court acknowledged these errors. I mean, and there were others involved. As the court said, when humans finally looked at the case, this is, the tax court, saying, look, nobody ever really looked at this until we finally got far along the course, and there had been so many screw-ups it wasn't funny. Finally looked at this case as our trial counter approached. All agreed it made sense to remand the matter to the IRS for another hearing. Right? The hearing had not actually taken place. It was all fouled up, and there was no question. The IRS even effectively now is admitting they're going to screw up in court. Unfortunately, the taxpayer, I don't know if they felt emboldened because the court had seemed to be, taking a hard line with the IRS on this case, whether they were just upset, they just like to play hardball. I have no idea, but they decided now is the time to play hardball. Only problem is, it turns out, as they're going to discover, the IRS had an even harder ball, right? They're going to throw something high and inside and make a connection in this case, because the hard ball is going to backfire horribly on the taxpayer, right? The second hearing, while intended to be more reasonable, also had issues, so this didn't help matters, right? The settlement officer requested additional information from Mr. Nelson's, including their 2019 tax return. Additional information, right? Now, this is where the court says, okay, guys, you have to understand this. Bottom line, a failure, this is from a published tax court decision from 2007. A failure to be in compliance with tax filing obligations is by itself reason enough for the IRS to deny a proposed compromise. All they need is you didn't file the later returns. Now notice, it says all they need. You want the perfect rule to play hardball with? The IRS has it here. You have to be ready for that. The IRS now knows that mistake, taxpayer, is going to kill your case. This is not the thing to play hardball with, right? You don't want to be up there with a well-known pitcher that definitely throws high and inside and just go stand over the plate, which is effectively what Mr. Nelson is about to do. Okay. Now, basically the settlement officer did not provide a deadline for the information, nor an explanation of why it was needed. And the settlement officer's superior is going to even recognize that this seems to be a bit, no, right? This was not a reasonable opportunity to submit documents. So they went back, and the settlement officer then provided a new request with a 2-week deadline. Now, you could argue maybe that was still not reasonable. You can do lots of things, but the taxpayer decided to go right into the IRS's wheelhouse here. We're going to keep the hardball side of this going forward, right? And they became the ball being hit over the wall, right? As they decided to go the one place they shouldn't go. Rather, despite this, the Nelsons refused to cooperate. And this is where we get two statements from the person representing them in this case for the tax court, right? The court noted by now that the taxpayers are behaving unreasonably. Bruce Stevenson, who was representing them, called and informed the settlement officer that he had spoken to the taxpayers, and the taxpayers had stated, in essence, Nelson stated he was not going to provide any documents. Okay, that is almost exactly the wrong thing to say, as we're noting here. You are on a rule you can't afford to violate. Yeah. He further admitted, his representative, that I asked Mr. Nelson if he wanted to provide more information to the IRS, but based on the prior experience of Mr. Nelson, he decided not to waste the time and effort. Great. Exactly the wrong place. Is Mr. Nelson justified in being upset? Almost certainly. However, his response is not going to work. Right? This is where the problem is. Remember, failure to provide information, and failure to provide request financial information, and failure to show compliance with subsequent tax laws, or even fail to actually comply, which he hadn't, is enough by itself to get the thing thrown out. Basically, the IRS, everything the IRS did wrong, Mr. Nelson just made right by going down this path instead of challenging them as still being unreasonable, which I think the court might have agreed with. But he didn't do that. He decided to play this game. As he refused to provide additional documents in the missing 2019 return, the IRS again, supplemental notice of termination. Sorry, your relief is denied. And this goes. The court emphasized there is no abuse of discretion when a taxpayer fails to comply, complete financial information, and is not in compliance with their filing obligation for prior years. Either one of those would have been enough to disallow this. And he went for both. He went for the double. Right? There is no genuine dispute that this is just what happened here. Right? That's bad. Okay. So discuss this. Sometimes you've got to talk taxpayers down from the ledge. There are people that like to be belligerent, that like to play hardball. There are people that don't start out being belligerent, but will respond that way if, when faced with incompetence, when faced with other structures. The problem is, as an advisor, you got to be really, really careful. Now, we don't know what Mr. Stevenson did or didn't do. I suspect he may have tried to do this, right? To tell them you really got to provide this. This is not the sort of thing you can hold back. But the client just dug in. I think this is when somebody has got to be able to have that face-to-face and saying, look, what you're doing here is going to backfire horribly. It's going to backfire entirely. Now, we can argue that the 2 weeks is not a reasonable time frame. We can argue all of that stuff, but your flat out statement that you are not going to provide the data and it's a waste of time, you won't do it, means you can't get relief. Bottom line, calm down, do what you need to do. Don't just, yes, you may feel better right now that you're going to put it to the man, but you're going to get hammered hard. In essence, in the end, you will be the loser. And while you may feel, you may have justified, concerns, justified issues, you may feel wronged. Gang, you got to look, when you're playing hardball, you got to play by the exact rule book. And in this case, that rule book was very much on the IRS's side in the areas that you decided to make your last stand on. Anywhere else would have probably been good, but you went for the exact thing that gave them a win. So this is the equivalent of soccer, the own goal, where you just kind of put it on your own goal. Yeah, you put it in yourself. With that, this has been the current federal tax developments for the week of, February the 3rd. I remember which month it is now. Current federal tax developments brought to you by Kaplan Financial Education and your state-sized CPAs. If you have any questions, you can ask me, edzoller's@currentfederaltaxdevelopments.com. I'll try to answer them when I see them. I also try to keep up with discussions on the groups for the New Jersey Society of CPAs, Arizona Society of CPAs, Minnesota Society of CPAs, Illinois, get all my things together here, Washington Society and Idaho Society on their Connect site. So if you are a member of those, you can post there, and if I see something, I may respond. Otherwise, hopefully we'll see you back here next week. We probably are still going to be talking mainly about court cases. We'll see if we get any sort of administrative guidance from the service or anything coming out of Congress. But despite the fact that the House Republicans had their big meeting this past week to try to set up, and they're going to try to run and start the reconciliation process this week, reports were, at least as of the end of the week, no great huge breakthrough had occurred. And that's a real problem in the House. For us to get going on the TCJA extension, we need to get the reconciliation process underway. And one report in tax notes that'll be appearing Monday came from a former tax advisor on the staff of a former speaker, who essentially says former Speaker Ryan, who basically was there when Tax Cuts and Jobs Act went through, that his called it over-under on when the tax bill passes, when they finally get something through with the tax bill, is January 1st, 2026. So, but I will also say there is a wide range of, let's say a wide spread of dates around that date. So it could be much earlier, and the really sad part is it could be much later. So we still have a lot of unknowns right now. So keep an eye on that. If that happens this week and we actually get something moving, then we might discuss quickly what's in there. But otherwise, we'll see what comes up. So join us back here next week for more current federal tax developments.